Can you get service connected for a condition that pre-existed your military service? Welcome to VA Made Easy. I'm VA-accredited attorney and U.S. Army combat veteran Ed Farmer. Today we're going to discuss two presumptions that make it difficult for the VA to deny you service connection for pre-existing conditions. If you've been denied your claim, visit me at vetlawoffice.com. We provide zealous advocacy. We'll prep you for your C&P exams. We'll help you obtain those medical nexus opinions. Set up a free consultation at vetlawoffice.com or call 1-800-700-4174. There's no fee unless we win. But for now, let's get into it. There are two presumptions that make it really difficult for the VA to deny you service connection for a pre-existing condition. The first one is called the presumption of soundness. And this presumption is found at 38 U.S.C. 1111. And what the presumption of soundness says is that every vet entered military service in sound condition. In other words, the veteran had no diseases or injuries or disabilities prior to entering the military service. The presumption of soundness really limits the VA's ability to deny you by just saying a condition or injury pre-existed service. They have to presume that you entered the military service with no defects or diseases or injuries. Now, sometimes the presumption of soundness doesn't always apply. If a condition was noted when you entered military service, in other words, on your military entrance exam or for National Guards and reservists on your pre-deployment exam, if a condition or injury was noted on that, then the presumption of soundness does not apply to you. So take a look at your military entrance exam or your pre-deployment examination and see if there are any conditions noted on there. Even if a condition was not noted on there, the VA could still rebut the presumption of soundness. But the VA has a very high burden to rebut that presumption of soundness. They have to show by clear and unmistakable evidence that that condition pre-existed service. Now, this is something that the VA routinely screws up. They don't understand the definition of what it means to be clear and unmistakable. The courts have said it means undebatable. It means that only reasonable minds could come to the conclusion that a condition pre-existed service. Now, we all know VA adjudicators aren't the most reasonable, but that is the standard. Now, what sort of evidence amounts to clear and unmistakable evidence that the VA could then rebut the presumption of soundness? One, they have medical records showing treatment or a diagnosis for that condition that pre-existed service. Two, an admission by the veteran that it pre-existed. Three, you have a congenital condition. That means you're born with that condition. Now, it may get a lot of grief in the comments about this, but one of the most common congenital conditions is pes planus or flat feet. Most people are born with flat feet or pes planus, and they don't realize they have it until they actually enter the military service. And four, a medical opinion saying that this condition probably clearly and unmistakably pre-existed service. Those are some ways that the VA can rebut the presumption of soundness by clear and unmistakable evidence. So that's the presumption of soundness. Even if the condition's noted on your entrance exam or the VA is able to rebut the presumption of soundness, that's not the end of the analysis. The VA next still has to show by clear and unmistakable evidence that the condition was not aggravated by service. So in other words, the VA now has the burden to show that that condition was not aggravated. And there's another principle to help you win these claims. It's called the presumption of aggravation. So if you have a pre-existing condition and that condition underwent an increase in severity while you were in service, then it's presumed that condition was aggravated by your military service. So for example, if you went into the service with flat feet, you had no issues with flat feet before you went into service, and then all the marching and wearing of the boots aggravated your feet to where you had pain and you couldn't stand or walk for long periods of time, that would be considered an increase in symptoms. However, the VA could rebut the presumption of aggravation as well. So one way the VA could rebut that presumption is by saying that the increase was temporary. So in other words, the symptoms increased and then got better. Two, they could say it's due to the natural progression of the disease. In other words, that condition would have got worse regardless if you entered the military service or not. That's just the way the disease progresses. Or three, a medical opinion saying that the condition was not aggravated by service. All right, so let's recap here. In order to deny you for a pre-existing condition, the VA has to do two things. They have to, one, show that by clear and unmistakable evidence that condition pre-existed service. And if they're able to show that, then they must show by clear and unmistakable evidence that the condition was not aggravated by service. If they're unable to meet one or both those conditions, then service connection should be granted. But let's get real here, folks. This is the VA. They screw this analysis up all the time. They don't seem to understand the rule. They don't seem to understand the burden of clear and unmistakable evidence. If you've been denied service connection for a pre-existing condition, visit us at vetlawoffice.com or call us at 1-800-700-4174. And that does it, guys. Keep liking, keep sharing, keep subscribing. And remember, you have the power to change your VA claim.